Constitution. That means lawyers are instrumental in maintaining the legal decorum of an entire nation. I, Amrapali Sharma, the co-convener of Organizing Committee, extend my heartfelt welcome to all the present dignitaries here. Honorable Mr. Justice Bhavar Singh Sir, our respected Director General, Mr. A.K. Singhal, who has graciously agreed to be the chief guest of our ceremony. He is a senior advocate in the Supreme Court of India. Professor Dr. Ravikant Swami, our director, sir. And last but not the least, our Dean, DME Law School, Professor Dr. Rashmi K. Nagpal. The legal system has ordained the councils with the mighty responsibility of bridging the gap between the seeker and the justice. Thus, with an objective to nurture and hone their counseling skills, DME Law School has organized its second National Client Counseling Competition today. Now, I would like to call upon Honorable Mr. Justice Bhavar Singh Sir to kindly felicitate our esteemed chief guest for today's inaugural ceremony. Thank you, sir. Now I would like to call upon our director, sir, to felicitate our esteemed guest who have accompanied our chief guest for the today. Ma'am, please join us on the stage for felicitation. Thank you so much, sir. Now, I would like to hand over the mic to Dhiman and Khushbu for further conducting the ceremony.
Thank you so much, ma'am. So today, to grace our occasion, we have our Director General of Delhi Metropolitan Education, Honorable Mr. Justice Bhavar Singh sir. His Lordship graced the office of the Registrar General Supreme Court of India from February 1998 to March 1999. Later, he was elevated to permanent judge of Allahabad High Court from March 1999 to January 2007. His Lordship adorned the august office of Chairman, Judicial Training and Research Institute, Uttar Pradesh from 2012 to 2014 and has been part of many sterling judgments, like the High Court judgment on the Ram Janmabhoomi case. We would like to invite Director General Delhi Metropolitan Education, Honorable Mr. Justice Bhavar Singh sir, to shower us with his blessings and set the tenure of the event.
The chief guest of this event, Mr. Anil Kumar Sangha, Dr. Ravikant Swami, Director of Delhi Metropolitan Education, Dr. Rashmi Nagpal, Dean Faculty of Law, the faculty members, the guests who have accompanied the chief guest for the budding lawyers, and participants. I welcome you all to this second event of client counseling. Client counseling is an art of giving advice to a litigant who has come to a lawyer to seek his assistance by offering payment. Consilium is a Latin word from which the counseling has been derived, and virtually it is a skillful art. It's not very simple to advise a client. The Bar Council of India, which is the apex body of this profession, has prescribed many rules for the legal profession, such as ethical norms, bench relationship, contempt of court, moot court, pre-trial procedures, negotiations, interviewing of the clients, counseling, drafting, etc. Under the code of ethics, a lawyer cannot refuse a brief unless there are exceptions. So the counseling acquires greater significance and the greater art of skillful interview of a client. It is the responsibility of the lawyer to collect the fact story, and as is the practice, the client cannot be forced to reveal the truth. For instance, if an offender of the offense of a murder comes for advice, you, by your skill, have to elicit the true fact story. But you cannot force that, reveal me the truth, whether you have committed murder or not. On civil side, the position is slightly different. Unless a lawyer will be in a position to know the real facts, to know and identify the witnesses, to take out the relevant documentary evidence, he will not be able to advise properly. So, the art is there in tackling the client with your high skill. The best interests of a client are to be served, and as I said, interviewing is the lifeblood of the entire procedure of interview. Friends, after interviewing and identifying the important facts, the documents, the witnesses, the next responsibility of the lawyer is to build a relationship with the client so that he can create a confidence in you, a relationship of mutual trust is built thereon, so that he can tell you everything he knows about his case. As Bar Council of India has prescribed, a lawyer is expected to behave with etiquettes and well manners with his client, and also it is the responsibility of a lawyer to give the correct advice, including the weaker points of his or her case. It is also said that though the payment is there in between the advice and the counseling, but at times the pro bono service is also suggested by the Bar Council of India. And I recollect a few years back, our chief guest, Mr. Singhal, must be remembering that Ramjet Malani was engaged by Kejriwal to plead a case on his behalf. Kejriwal asked for the fees, the amount of fees. Ramjet Malani said, see, besides being a lawyer, a politician also, I may not require fees from you. But then Kejriwal insisted. Ramjet Malani then conveyed that if you are really insisting, though I know you won't be able to pay my fees, then here is the bill of rupees 6 crores. So, the senior advocates, with the exception of Mr. Singhal, are indeed realizing very hefty fees. And as I hear, because I have never been in profession, though my son is, that the senior advocates are realizing some 30 lakhs rupees per day for arguing a case. And if the case is adjourned, another 30 lakhs is required. So, but it's a part of the ethical profession of lawyerism that in deserving cases, pro bono service is also rendered. Then the real story, that is the true facts, must be presented before the court without there being any twist or the falsification. I remember the anecdote of A.B. Godrej, who was a lawyer in the days of our independence movement, that is freedom movement. A.B. Godrej was a lawyer. He was asked by Gandhiji to go to South Africa and contest a case. Since he himself was in the freedom struggle, so he obeyed Gandhiji, though reluctantly, but then he went along with the client. And the client insisted that, sir, if you twist a bit my facts, then certainly I'm bound to win the case. Initially, Godrej refused to do this. No, I will never do that. But the insistence by his client forced him to twist the facts. And the judge came to know this. So he had to lose the case. He dismissed the petition being argued by Godrej. Godrej fact, guilty conscience, that it is my mistake that I have twisted the facts. Even if my client insisted and asked me to give a twist in the fact story, I should not have given. And he felt so much guilty conscience that from that very day he decided to relinquish the profession, and he came to Gandhiji, asked for entering into manufacturing of some good items. Initially he went into the medical equipments, but he couldn't succeed there. And it's a very interesting story further also, that when he started the Almirah and locks business, he went to a creditor to borrow a loan. Boyce, Kanga Boyce, if I remember the name exactly. The loan was extended, it was a huge loan. And after a few years, Godrej went to return that loan amount. Then Boyce said that no, I won't like to have it back, but you do one favor to me. I have a vagabond nephew of my own. You just make him a partner to any extent, 10, 20, 25%. But Godrej felt so much indebted to that creditor that he offered 25% partnership to his nephew, Boyce. And then the business of Godrej flourished. It started flourishing, and it is still flourishing. When Godrej was in his last days, he said to his successors in the family, in the business, that Boyce should always be kept on the partnership deed. And even today, this firm is called Godrej and Boyce Manufacturing Company. It is how that lawyers have been doing. There are many other stories, but because of the paucity of time, I may not tell upon them. And it is the privilege of the chief guest to be a keynote speaker. I will wind up therefore with a few sterling qualities of a lawyer while counseling their clients. That because he has to be, the client has very high expectations from an advocate, then the advocate is accepted to be very knowledgeable and very competent. The interpretation of the Constitution, true Constitution. Once I had the occasion to meet a very famous lawyer, R.K. Garg, Mr. Sengel must be remembering him. He is no more in the field, but at one point of time, Mr. Sengel belongs to Muzaffarnagar and R.K. Garg belonged to Saharanpur. So I went to invite him for a law faculty event. So he came. But when I went to fetch him at his office in the morning, so he was reading Article 14. And reading it, it is 2.5 line article, it is reading again and again, again and again, again and again. I was watching him. So I couldn't restrain myself. I had an inquisitivity. Why he was reading it again? And when I asked, he said that Mr. Bhavar Singh, as many times as you read Article 14, you will find a new idea. So that is the spirit of a council. He was senior advocate at that point of time also. And competent of law, and then the latest decisions of the Supreme Court. See, what Supreme Court says, it says, whether it is there in the Constitution or it is not. Collegium system is nowhere written in the Constitution, but it is there. Indian Judicial Commission was quashed by the Supreme Court. The legislation was quashed because it did not conform to the judicial norms, the basic structure of the Constitution. And Golaknath case, nowhere written in the Constitution that Parliament will have no right to amend the fundamental rights. And likewise, Keshwanand Bharati case, what it was said by the Supreme Court, that amendments can be made, but not to the detriment of the basic structure of the Constitution. These are the decisions of the Supreme Court. And I remember some around 200 years back, I'm subject to correction, perhaps Chief Justice of America Holmes said that what it just says is the Constitution. So, friends, as a lawyer, you have to have the latest knowledge of decisions. It is different that Justice V.R. Krishna here once said, we live in a strange country. Here, the legislators, the parliamentarians, the MLAs, they increase their salary, and the judges, they appoint judges. So we live in a strange country. Whatever is, the fact remains that the Supreme Court's word is a final word, and it is because it is the apex court. So, not only the knowledge of law, but the latest decisions of the Supreme Court must be on the tips of the lawyer so as to correctly advise his or her client. Friends, with these words, I wish you good luck, and I pray that this event goes a great success. Thank you. God bless.
Thank you, sir, for your inspiration and blessings. It was indeed an enriching experience to hear you. Now, we would like to welcome our respected chief guest, Mr. Anil Kumar Sangal, Senior Advocate, Supreme Court of India. Sir is practicing in the Honorable Supreme Court of India for the last 40 years and has also worked as the Standing Counsel for the state of Assam and as Senior Advocate for the state of Uttar Pradesh. Sir has also authored a book on philosophy, The Holy of Holies, The Theory of Everything as I Understand, a metaphysical philosophy transgressing the science. Sir, we would like to request you to shower us with your kind words.
Good morning, everybody. Honorable Justice Bhavar Singh, Director General DME, Professor Dr. Ravi Kant Swami, Director DME, Professor Dr. Rashmi K. Nagpal, Dean DME Law School, I deem it my proud privilege to have been invited to give this keynote address to this commencement function of the National Client Counseling Competition The profession of law is a very novel and noble profession. It is the learned profession. The advocates have special status and privilege in the society. But at the same time, the profession of law is very demanding and challenging. The first and foremost, when anybody joins the profession of law, the problem is how to get a client. The question of client counseling arises later once you have a client. For the beginners, the first question is how to get a client. You can't solicit, you can't advertise, you can't converse because the Bar Council rules prohibit you from doing all that. Justice Bhavar Singh sir has already enlightened you about the ethics of a lawyer, of a lawyer to the lawyer, of a lawyer to the client, and also of a lawyer to the court. I tell you a simple formula to be successful in profession. The lawyer has to be very social and affable. He must conduct himself with dignity and self-respect. He has to be very humble, very friendly, very social, because each of our acquaintance, be it a relative or a friend, is our potential prospective client. More people you know, more is the possibility that you will be successful in the profession. But profession is very demanding and very challenging. As it is said, it is not a bed of roses. You can't get both. Either have the roses or have the bed. If you have the bed, you will miss the roses. And it is also said to be jealous mistress. The profession has to be your first priority to be successful. Therefore, it is said it is a jealous mistress. You have to keep all your other priorities on the side, and profession should be your first thing. The subject today, the client counseling competition. As I understand it, I don't think that it is the duty of an advocate to teach the client the law. A lawyer doesn't run a tutorial house. Even for juniors, juniors have to learn themselves by being in our chamber. They can't expect us to teach them the law. But nonetheless, client counseling is all about advising the client about the case so as to make him capable of taking his own decision. about the recourse of law he has to resort. A duty of a lawyer stops there. After advising the client about the implications of his proposed actions, that is all I understand about client counseling. But there are a few things which must be borne in mind while counseling a client. We must talk and interact with the client in the same language and dialect as is of the client. We must make him comfortable. That is the first thing. And at every stage of counseling, the client should feel free to stay with us or to leave. He should be totally free. Though before the effective counseling, it is a good idea to get the papers and some narrative before actual interaction takes place. We have to be frank with the client, but we should never be judgmental. Client doesn't come to us to be told that he has no case. We should never make the client hopeless. He comes to us with great expectations. We have to keep his nerve. A lawyer has to be logical, critical, positive, and optimistic, and also far-sighted, as is a player in the game of chess. The lawyer should be able to think many steps ahead, like a player does in the game of chess. So, I want to highlight 2-3 more things. As Justice Bhagat Singh has told you, the law is equally as contained in the judgments of High Court and Supreme Court. It is by virtue of Article 141 of the Constitution that the law declared by Supreme Court is binding all the courts in India. Then under Article 42, Supreme Court can pass any orders in order to do complete justice between the parties. It is this article which makes Supreme Court also a court of equity. Supreme Court is not merely a court of law. It is equally a court of justice and equity. And then there is Article 144, which says all the authorities, civil or judicial in the territory of India, will act in aid of Supreme Court. Therefore, in the dispensation of justice, the Supreme Court can take assistance from anybody, any authority within the territory of India, and every authority will be bound to assist the Supreme Court, be it the district judges or the High Court judges or the district magistrates. This is by virtue of Article 144. I would not deal with the other jurisdictions of the Supreme Court because that would need a special session, a different session altogether. Some other time, about especially jurisdiction, jurisdictions, advisory jurisdiction, transfer jurisdiction, right? But I want to converse before you, no interpretation of law by any court, including the Supreme Court, is final. No case is a hopeless case. I will illustrate these points because in my experience in Supreme Court I have seen that the best of the cases are uncharitably dismissed and worst of the cases are unceremoniously allowed. This I say in my own experience. And short of committing any contempt of court, I have no hesitation to say the Supreme Court works as a fluke. To illustrate, the Golaknath case was decided in 1967 by a bench of 11 judges of the Supreme Court, where the Supreme Court by majority held that the fundamental rights cannot be curtailed or abridged or taken away. Anybody in his senses would believe and trust that amounted to settling the law. A judgment by 11 judges of the Supreme Court. What remains? Thereafter, in 1971, the Constitution was amended by 24th Constitutional Amendment Act. And there they said that any law made under Article 368 of the Constitution will not be the subject of the provisions of Article 13 of the Constitution. This amendment came for the Supreme Court consideration in 1973 before the full court in Keshwanand Bharti case. There, the full court unanimously held upheld the amendment and overruled Golaknath's case. And at the same time, by a thin majority, the full court, 13 judges, in Keshwanand Bharti case, also said that the basic features of the Constitution, which may affect the basic structure of the Constitution, cannot be altered or amended. Though thereafter again there was amendment, 64 amendment, and Minerva Mill case where they declined to be abided by the amendment which says that the Parliament has an unfettered power to amend the Constitution. In the 64th amendment. Now in Keshwanand Bharti case, they have significantly said the fundamental rights are not the basic features of the Constitution. the fundamental rights and block are not protected. But there may be some fundamental rights which, if amended, may affect the basic features of the Constitution, that on that ground, that could be nullified by the Supreme Court. So the point which I am trying to make is that no interpretation of law or Constitution is ultimate. A good lawyer should always be skeptical about the law laid down and should not be swayed by the fact that law is settled. The difference between the psychology of a district court lawyer or a high court lawyer or a Supreme Court is this. A district lawyer, I don't mean any disrespect to anybody, please excuse me. Once the High Court lays down the law, a district lawyer would generally say, now the law is settled. Similarly, a High Court lawyer would say, that now the law is settled by Supreme Court. A good lawyer should never believe that the law can ever be settled. This is the beauty of the law. This is the beauty of the law, this is also the difficulty of the law, is that the law is never settled. And also I want to bring home the point, no case is a hopeless case. If sir permits me, I list it. I was appearing in that case, in the recent case of 2021. I was appearing in that case for the State Bank of India. My role was limited. Otherwise, the controversy was between the Government of India, Agricultural Ministry, and the borrower. The borrower company, namely AB Refer, was provided back-ended subsidy for his term loan. The borrower, AB Refer, was provided back-ended subsidy is, which is not given straight away, but it is adjusted in the last and final installments of repayment of term loan. If anybody had come to me, can this back-ended subsidy be adjusted against my defaulted installments of term loan? I had said there is no question. But in this particular case, the borrower, AB Refer, went before the Punjab and Haryana High Court, and Punjab and Haryana High Court decided you can't declare the account as NPA as long as you have in your bank the subsidy amount of 14 crores. You take the installment, you adjust the installment against that, and ultimately direct. The bank has to adjust the subsidy amount towards the outstanding installments. Am I clear about facts? Yes, sir. The Government of India came in appeal before Supreme Court. Namely, the Ministry of Agriculture filed SLP in Supreme Court. The SLP has been decided. And Supreme Court has upheld the judgment of the High Court. Any one of you could easily understand the implications of back-ended subsidy, but the High Court and the Supreme Court took the other. Now we are as a bank, we are facing contempt of court. We have adjusted the subsidy amount as directed by High Court and the Supreme Court, and thereafter we allowed the one-time settlement. But the borrower wants that you first arrive at the one-time settlement, then offset it against the subsidy amount and refund the balance to me. Outstanding amount was 42 crores. Subsidy amount was 13 crore. OTS amount came to be just 10 crores. He says out of the subsidy amount of 13 crore, you adjust 10 crores towards OTS one-time settlement and refund 3 crores to me. As a bank, we said, no, this can't be done. We will first adjust the subsidy amount, then calculate the one-time settlement. So, the borrower has filed a contempt petition, which I am defending. The Supreme Court has issued notice, and looking at my reply, they asked the borrower to file a rejoinder to my reply to the counter affidavit, and has fixed it for hearing on a non-miscellaneous day. The Supreme Court, if the court decides to dispose of the matter at the admission stage, they fix it on a weekday. Other Monday and Friday are miscellaneous days. So court has directed it to be listed on a non-miscellaneous day. Meanwhile, one of the judges has also retired. Anyway, so I wanted to bring home the point that no case is a hopeless case. You have to be frank with your client, but try not to be judgmental. Being judgmental is something different. To be frank, and while discussing with the client during counseling, talk to him about the positive points only. And the other contentious issues, difficult issues, issues involving legal nuances should be kept for being deliberately among the councils separately. And last and not least, I would say, the lawyers are capable of arguing anything. They can argue anything, and that makes them a true lawyer. Advocacy starts when the facts of the case are not good on merit, when the facts of the case don't support you. Advocacy starts there. A state case anybody can do. So can I illustrate it? In a court of law, the arguments were going on between two advocates. One was arguing that the crow is white. Others said no. It is a common knowledge. Crow is black. But the advocate who was arguing the crow is white was very adamant, very stubborn, was not prepared to listen to the bench. My case is that the crow is white. The presiding judge tried hard to persuade him. Ultimately, the judge said, your father is a senior advocate. He is present in the courtroom. Why don't you go and ask him? He will tell you. The lawyer who was arguing that the crow is white went to his father and asked, Papa, please tell me. The father rose and said, sorry, my lord, I can't say anything because the matter is sub judice. So the judges can decide anything, particularly the Supreme Court judges can decide anything and everything. And what they say is correct because it is what they say. And Justice Sir said, there is no provision in the Constitution for a collegium. Collegium is a totally outcome of various decisions of the Supreme Court in this regard. It's a judgment law, and many times Supreme Court say no, it is not none of our function. And recently they have quashed a judgment of Justice Goel on the ground that no, we can't make. And Justice Goel, now he is chairman of NGT, had made a very sensible judgment that once a complaint is made by somebody about the untouchability or something like that, it's a non-cognizable offence. Justice Goel said in such cases, if the allegation is against a government servant, he should not be arrested except with the sanction of the superior officer. Or if such thing is said by a common man, there should be an inquiry about the genuine, and then only such person should be arrested. Modi's government filed a review petition, which was listed before Justice Mishra, 3-judge bench. They have quashed the judgment of Justice Goel, and this was done just to appease the community. This reference. They say that no, Justice Goel has exceeded his powers as a judge. But while developing this collegium system of appointment of High Court and Supreme Court judges, and sometimes transfers are made very insensitively by way of punishment. So anyway, it was pleasant for me to be here today. And I congratulate all of you for choosing such a remarkable topic, client counseling. In the beginning, I was a little jittery, skeptical as to what it is about. We have always grown with the feeling that it is not our job to teach client the law. And here I feel client counseling is all about advising the client to make him capable of taking an informed decision about the recourse he should take for redressal. This is what I put together. And today's topic is, I think, family law. And I want also to congratulate the team which has made this brochure. It is so meaningfully, so wonderfully drafted. And it is in itself is a thesis on the subject of client counseling. It talks about interchangeability of the word counsel and advocate. Usually the courts, particularly the High Court and the Supreme Court, they address an advocate as counsel in the judgments as well as in the court. But here a difference has been tried to be made, and I think rightly so. And counseling we used to call consultation. In my times we would say consultation. And client counseling I think is something deeper and higher. I will try to correct myself on this score after reading this brochure. And today's topic is family law. Family law is a very tedious but at the same time very interesting subject. And insofar as Hindu Succession Act is concerned, earlier proviso to section 6 was a very difficult proposition. Now section 6 has been amended in 2005 to make daughters as a co-partner. Therefore, the things are further complicated. The judgment has come recently in Vinay Sharma case. It says the partition which will occur thereby will be the real partition, but what will be the ultimate character of the property after partition is not clear from the judgment. The Constitution mandates Uniform Civil Code, Article 44 of the Directive Principles of State Policy, envisages that there should be a Uniform Civil Code. In the Supreme Court, as far back as I think 1995 or 97, in Sarla Mudgal's case, directed the government to enact Uniform Civil Code. Some work is going on that score, I am told, but nobody knows when will it fructify. And in our democracy, there are so many political constraints, be it limiting the population or eradicating the reservation. Supreme Court had given an excellent opportunity to the government by refusing any reservation in promotions in Prime Minister Vajpayee's time. The Constitution was amended so as to provide reservation in promotions as well. Nobody is prepared to take any unpleasant decisions. So thank you again. Listen me. And I must mention that I am particularly very happy after meeting Justice Bhavar Singh in his chambers for a cup of tea before joining here. And the conversation that we had together was really excellent and rare. And I congratulate you to have a person like Justice Singh as your Director General. So, thank you very much, esteemed faculty members. Would I say something about my book? Sir, I will take 2-3 minutes. I have written a book, The Holy of Holies. The title of the book is The Holy of Holies. And this book is in fact me personified. This book includes everything right from the genesis of the universe till other practical things. The basic thing about the book is that it says that there is no God as such sitting anywhere in the skies. I'm not saying that there is no God. What I'm saying is there is no God sitting anywhere in the sky as such. This is the basic. Though somewhere I have illustrated how everything is God and there is nothing but God. And the second basic postulate of the book is that the things simply happen. You will never know why. By any amount of effort or logic, you can never know why the things happen. So, the things simply happen. For example, in a game of cards, the players get different cards. Can you determine by any logic why A gets good card, B gets not so good cards? What is not? What is in your hand is to play the cards. So is the life. Things will happen. You should not waste your time to know why such and such thing has happened. We spend 90% of the time in fixing the responsibility and 10% time remains to solve it. However, it should be reversed. When a thing happens, 90% of the time should be to decide what we should now do. And I have a few copies of the book in my conveyance. If anybody would be interested, I will be glad to gift complimentary copy of my book to such person. Okay, thank you. Bye-bye.
Thank you so much, sir, for the insightful understanding that you shared with us today. Now we have amongst us Professor Dr. Ravikant Swami, sir, Director, Delhi Metropolitan Education, Noida, to share his words with us.
So, dignitaries present on the stage and all the guests, it's an important day for this college today because we have students from, I'll say, all parts of India. Yeah. So, we have students from all parts of India for participating in this national client counseling competition. Well, when we talk about a law school, mooting is something which is now becoming cliche. And things like trial by advocacy or client counseling are becoming popular. So we also thought that we should have this competition. So this is the second national client counseling competition. The theme, I must thank our dean and the team for choosing this theme because the world moved from an agriculture-based society to a manufacturing-based society to a service-based society. And therefore the fabric of our society changed. So the things which were very much relevant in the agriculture-based society are no more relevant today. And the best example is joint family system. The joint family system was there in the agriculture-based society and there were reasons for that. That society, that joint family system, I must say, cannot work in the present fabric, in the present times. So the family system is evolving, it is changing, and various concepts are coming, and I must say that we are going the Western way. Western way where people ask two questions to themselves. One, why should I marry? Second, why should I have children? So we going the Western way? Yes. So I believe the theme of this client counseling competition is very relevant, and all the teams are going to have a good time here. We wish success to this program. Thank you.
Thank you so much, sir, for your kind words. We are also delighted to have amongst us Professor Dr. Rashmi Khurana Nagpal ma'am, Dean DME Law School. Ma'am is a visionary and has got years of experience in academia. Now, we would like to call ma'am on the dais and raise the occasion.
Thank you so much, dear. A very good morning to one and all present in this August gathering. At the onset, I am very thankful and equally grateful to Shri Anil Kumar Sengal, ji, he's the Senior Advocate, Supreme Court of India, to be here this morning, taking time out of his busy schedule to be here with us on a different platform altogether, where he's not used to these kinds of platforms. We wanted to share, listen to his experiences. I'm extremely thankful to our mentor, guide and teacher, Honorable Mr. Justice Bhavar Singh, Director General, Delhi Metropolitan Education, our director, the leader behind all our endeavors, Professor Swami, Director DME, to all my faculty colleagues, Dr. Dhava, Academic Coordinator, the organizers of this event, at this point of time where most of the colleges are still closed, and above all, the participating teams for today. When I look back, I sit in this seminar hall or in Nelson Mandela bigger auditorium that we have under renovation. Whenever I sit here and I look back to my old days in 90s, when I did my LLB program from Punjab University, Chandigarh, nobody knew what is moot court. At the fag end of the law degree program, 6th semester, that we got introduced to a concept like there is a moot court. And that too, restitution of conjugal rights would be the most common problem. Nothing else. And imagine that everyone was hesitant when it was a competition to be held. 2 teams participated for 3 prizes. And nothing like memorial was heard of. It was 2 pages that we presented and argued from both sides, and were very happy that Kapil Sibbal's father, Mr. Hiralal Sibbal, the leading lawyer of that times in Punjab High Court, was the chief guest. And then after the competition, we got to know as to what is restitution of conjugal rights and how we had to perform, and what is this moot court all about, because he had been to UK and to other countries number of times. So he had much better exposure at that age when he was in 80s. And then one occasion, we went to Punjab University Patiala for the competition. Just before 2 days of our final examination, a moot court competition, first time held in Delhi NCR. Again, restitution of conjugal rights. 3 teams, 3 prizes. So 2 dummies were created there only to save the face, and all were equally bad. This was all that we got an exposure to what moot court is. And with changing times, if we look at the law school today, we are ourselves at DME more in favor of promoting clinical legal education rather than the core books. This is the need of today, I feel. And this profession, legal profession, is like medical profession, is a helping profession, where the endeavor is that the client should not be a mute or a passive spectator. And these things, I think now our students are able to start at the onset at the Supreme Court level, where we used to fumble at the name of even High Court. So this is making a lot of difference. I think most of the law schools are encouraging these kinds of programs. Some I've seen are not into this exposure of art of advocacy or client counseling. Small things make a lot of difference. We need to understand. And when you are here, please believe me, the competition is very, very fair. And we want the best to win. It is not about one memento or a meager prize money that you've come for. Those who came here will definitely be enriched by the experience. Let us forget that who is the winner, who is this runners-up, or who's got the consolation. It is each one is a winner. The one who stepped out, the one who prepared, the one who is ready to face the competition will definitely learn. When we are organizing, we are learning. When we are here at the podium, the comparing students are learning. The ones who are standing, making the arrangement are learning. The ones who are losers are those who are sitting at home. So we are all winners. And this clinical education, while I talk about that we don't have, as academicians, we don't have any exposure to the practical aspects of litigation. Neither do we face the client, nor do we do anything in the court of law. So one book which inspires us as academicians is that I tell everybody to read, though we are every day enriching ourselves with the experiences of Honorable Justice Bhavar Singh sir. I think if we keep noting down the anecdotes that he shares everywhere, every time it's a new one. Like Mr. A.B. Godrej's today was another new one. So we are fortunate to have him, as Sangal sir mentioned, to have him as our advisor here at DME. We get to learn every day. Each one of us is a student of law. And let us not forget one famous Chinese proverb is why do we need to promote clinical legal education is that says, I hear and I forget. I see and I remember. I do and I understand. So the best books and videos on swimming and cycling cannot teach us swimming or cycling. To go deep into the water, to learn. This is a step towards your becoming the best of legal, coming to the best of legal fraternity, best of the advocates, or later to be delivering the best of judgments as the justices of high courts. Thank you so much. Best wishes to all of you. May God bless you.
Thank you so much, ma'am. I would now request Honorable Director General Sir of Delhi Metropolitan Education to honor our chief guest with a memento, a gift, and books. Now we would like to request all to be patient for a group photograph on the foyer of the DME. Our volunteers will guide you definitely for that. So please move towards your waiting room.
Good afternoon, sir. We are really grateful to have you today for the inaugural ceremony of the National Client Counselling competition that is organized by DME Law School. So I was just going through this book, sir, which you have written. Just wanted to know, I really want to know that what inspired you to write this book? Like I've read your thoughts on a lot of things, the purpose of life, universe, the concept of dharma. So what inspired you to basically write this book?
Actually, I felt that I think differently than the general people think. And I believe also that religion has done more harm to the society in India and internationally than any other thing. I had my own notions about so many subjects where I thought with a different perspective, and therefore I desired that I should pen them in a book to the extent possible. That is the real inspiration behind writing this book by me.
Okay, sir.
And I don't see the God as a doer. This universe goes according to its fixed laws without any discretion, come what may. Every action, every thought would fetch a reaction, but in what way, that's a matter of nescience. Nobody knows. Even our thoughts send ripples in the whole universe, and therefore they have their own effects which are not known. If there was a God of the kind people generally understand and believe, there had not been any floods, no famines, everything had been on time. But in a way, God is not responsible for all that, because whatever happens, it happens as a result of common thought, common actions, and so many other factors which are still in the realm of nescience. And science is only a little of what is known. In science, we know the cause and effect relationship. To that extent, we are sure that if thing A happens, B will be the result. But that is only a marginal part of it. Mostly it is not known. And the whole science is built on this cause and effect relationship to the extent the principles of science are known. And largely they are unknown and still in the realm of nescience.
So, sir, apart from this, what piece of advice you can give to the young budding lawyers who are going to pass, in the coming session? Because they are going to, some are going to go and start practicing. For the first time, they have to appear in front of the court. So, what advice, what USP you think should be followed by them?
There was a time when the profession of law was a matter of last resort. Now, people consciously choose the profession of law as a career. The most important thing about choosing a career, be it profession of law or any other profession, is the interest. Anybody can excel only in the area of his or her interest. Because if somebody does a thing of his or her choice and interest, he or she will not feel tired, then doing the work itself will become an entertainment, and you can excel only in the field of your interest. This is first one thing. Second thing is, profession of law is very challenging. Challenging in the sense that anybody who joins this profession has to do very hard work and has to conduct himself in this society with dignity and self-respect, and has to make a place in the society, because unless the person who enters this profession gets the work, he will get no opportunity to show his talent. Successful are the persons who take the opportunity and the turning points as they come in somebody's life, and those who miss the opportunity, they remain a failure. Therefore, the profession of law, if you choose, then you should be ready to sacrifice to a large extent your other interests, and will have to devote more and more time to the profession of law. Otherwise, those who want to have free time all the time, they will have no place in this profession. Moreover, those who have inhibitions to speak in public, there is no place for such people in the profession. A man of wits can only succeed in this profession, and those who are very private persons, they seldom succeed.
Thank you, sir.
entire procedure, just make sure, just have this in your mind that we'll always be on your side. So, around the group proposal, administrative procedure.
Administrative items, like as this is your first session. No, sorry. Yeah. So, like as this is your first session, we'll be just charging you a standard consultation fee of rupees 2,000. Okay? Yeah. Like we'll see it at the end of it. That's it. The fees is not a problem. We consider it. Okay. So now, if you choose us to continue with us in the future after this session, then we'll be providing you the documents which has so many options of packages which you can upload. Okay. Now coming to confidentiality. Confidentiality is basically a set of rules. Okay. Set of rules which is done which is executed with the confidential agreement. I will give you the confidential agreement. You can read it, sign it, and bring back this. Okay. Now confidentiality is basically we will not share any of your information to others. Okay. We consider it as privileged information, and we are very sure that we will not share it to anybody else. Okay. Now coming to the conflict of interest, as there are both of us here, we always believe that both of our combined experiences will bring out the best outcome for your problem. Okay. We request you to tell all the information you know, no matter how irrelevant it may be, because the small nuances can bring out a bigger solution. Okay. So now, can you please tell us what made you come us to okay.
उनको इतना तो नहीं याद उनकी 91 में मौत हुई थी।
और आपकी बेटी का डेथ का कारण क्या था?
अटैक आया था जैसा हमें डॉक्टरों ने बताया, हमें तो पता नहीं था, हम माँ बेटी अकेले ही रहते थे।
मैम आपने अपनी बेटी को सो बेसिकली these are your details, the name, your address, your preferred mode of contact, some of your emails, some of your things you refer to their house. So these are some details you might have to fill out. But we can fill those later. But what we want to understand from this information is that this entire procedure, including the notes we take or whatever we talk about, is going to convey information. We cannot disclose any information to anyone. So the that reason, that's the first thing that is very simple. The second, as per this information, this is just an information conference. So the charges for that are rupees. And should you wish to instruct us further as your matter proceeds, the charges will be 6,000 rupees per hour. So, that's fine.
For the initial fee, we will be sending an invoice for this particular conference. However, as we proceed further and if you choose to proceed with us for subsequently, that is when, once the case ends, that is when we will provide you with the entire invoice of how much it is.
We don't mark any fees until the value consents, so don't worry about that. And should you feel that, is this fee okay with you? So, is it
And now we want you to be completely honest with us. We are going to tell you, we understand that you have
I can manage, but if you can reduce the so we have some financial assistance policies in place. We can discuss that later if the matter is in principle. क्योंकि हमारे पास है लीगल डिसीजन की पहले जो पैसे यहाँ पर से खराबी की बात होगी और यहाँ पे कोर्ट का ये मानना है कि जो व्यक्ति के माता पिता है उनको बच्चों किस कंडीशन में आराम दिया जाएगा तो भाई उनको नॉर्मल को आपको जाना अच्छी बात है और आप मजबूत हैं रही बात आपका जो मानसिक स्थिति हुआ तो आपका अभी होना हो या आपके बेटी का जरूरत है कब होना हो या आपकी बेटी का कब होना हो जो उन्हें घर से निकाल दिया गया इसलिए जो हमारा नजरिया है कि मसला बस एक है कि जो पार्टीज को एग्री पार्टीज है उनकी आपकी बेटी उनको हमारे बीच में ना होना कहीं ना कहीं कुछ उनके को थोड़ा सा कमजोर आपको इसी कारण है जो यंगर लड़के जो आप लोग हैं उससे हम थोड़ा सा हमें उठा सकते हैं और उसी तर्क पे हम उसे ग्राउंड बना के आपको आपका प्रॉपर्टी दिला सकते हैं
I'd really like to express a heartfelt thank you to both the finalist judges, which were Ms. Ananya Upadhyay, Anisha Upadhyay, my apologies, and Mr. Ninal Dogra. Both are the esteemed AORs in the Supreme Court of India. And they have been very patient with all our finalists, and I hope we were able to entertain you, our clients were able to entertain you, and our participants were able to live up to the expectations of good counselors in front of you. Thank you so much, ma'am. Thank you. And while we await for the results, I shall give the mic to Khushbu to proceed with the valedictory ceremony. Thank you, everyone.
Good evening to all of you. We welcome you all to the valedictory session of this event. We would like to call Ms. Vaishnavi Srivastava, ma'am, faculty co-convener for this event, to mark the opening ceremony.
Good evening, everyone. It is my utmost pleasure to address this exuberant crowd with burning legal aspirants. First of all, I would like to exert a heartiest congratulations to each and every team participant for giving their best efforts in this competition. With utmost sincerity, I would like to give my thanks to our dignitaries, Director General DME, Honorable Mr. Justice Bhavar Singh Sir, Director DME, Professor Dr. Ravikant Swami Sir, Dean, DME Law School, Professor Dr. Rashmi K. Nagpal Ma'am, and our esteemed participating teams. Along with them, I would also like to express my thanks to the faculty members and especially the students of organizing committee who were the backbone of this event, and with their constant hard work and efforts, we were able to make this competition a huge success. I would now like to call upon Honorable Mr. Justice Bhavar Singh Sir to felicitate our guest of honor, Dr. Arun Mohan, Senior Advocate, Supreme Court of India. I would now like to call upon Director DME, Professor Dr. Ravikant Swami Sir, to felicitate the judge for the final, Mr. Ninad Dogra, Advocate on Record, Supreme Court of India. I would now request upon Dean, DME Law School, Professor Dr. Rashmi K. Nagpal Ma'am, to felicitate the judge for final, Ms. Anisha Upadhyay, Advocate on Record, Supreme Court of India. With that, I wish prosperity for every student present here, and that they may become the rightful hands of justice up ahead in the future. Thank you, everyone.
Thank you so much, ma'am. We also have our Director General of Delhi Metropolitan Education. So, thank you so much, ma'am. I would now like to call Khushbu for welcoming our guest.
Thank you so much, Diman. We would now like to call our guest of honor, Dr. Arun Mohan, Senior Advocate, Supreme Court of India. In 1982, at the young age... Okay, sir. Okay. So actually, we would like to call you on stage to enlighten us on realizing your potential as a law student.
Namaskar. How many of you can give the exact meaning of the word namaskar? Hello. Yes, I want one volunteer. Yes? Namaskar. What does it mean? And more and more. Good afternoon, good evening, hello, hi. Is that the correct meaning?
Maybe, sir, namaskar ho ke bolna. I mean, thoda chupke.
Not near it, but not exactly. I'll tell you why I always say namaskar to law students, to judicial officers. The correct meaning of namaskar is I salute the divine in you. And why I salute the divine in you is the reason. You are law students. I am here today on their invitation, for which I am grateful. But I have a larger vision. To give justice to the people of the country, not through my hands. I have retired as a lawyer. But to share my ideas, to give you some guidance by which in the days ahead, maybe after I'm long gone, and you are top lawyers, judges, at your hands people get justice in the country. That is my mission. And how will that be achieved? That all depends on what you make of your days at the law school. Has this paper been circulated? Just give bunches of 15, 20, rest they can pass on. You see, I'm just telling you a imaginary story of two students who came to law school. One said, तुझे क्या करना है यहाँ पर 5 साल? मस्ती करनी है. The other said, अपने आप को कुछ बनाना है. What is the right answer is one thing. But what is the more important is what guidance you get. What is the mindset you fix by which you can make the best of your days at the law school. I look ahead, 10 years ahead. I mean, I'm taking you all at the start. Some of you must be already few years down the line. But let's take it 7, 10 years ahead. Where you are in life, with yourself, how you feel, depends on the foundation you lay within yourself in these years that you are in this law school. Question was asked, oh, I've learned all the statutes, I've learned this case law, I've read this judgment, now I know so many cases by heart. But that is not law. There is much more to law, something quite different. And I was so happy earlier when I was having a conversation with Justice Bhavar Singh that he has put a course to teach you the legal method. Legal method is the fundamental. And that is what you need to learn. But apart from that, it's the habit formation. What are your communication skills? What are your writing skills? All of us have habits. You have to shed your bad habits. You have to acquire good habits. And this is the time. And on this score, as I can see, all of you have been to good schools, you have been fortunate. But many times, some of your peers are not so fortunate. But if they make up their mind, they can make up also in your days here what they missed out at the law school, at the regular school, and keep it up. So that when you leave the law school, you can tell yourself, yes, I have achieved this. What does it require? Now, do you see a pie chart here? Well, I'm dividing this pizza into several tasty parts. The first is non-law general. Nothing to do with law. What is your personality? What are your social skills? What are your hearing skills, patience, speech skills, writing skills, thinking skills, critical thinking, logical thinking? These have nothing to do with law. They are to do with you as your own human self-development. Then, if you go clockwise, learning to learn is most important. I've not learned, but I've learned the art of learning to learn. You can learn tomorrow. But if you only go by what you have been taught, what resides in your memory, what you can recall, that is the end of your learning. So the distinction between the two, the importance of the first is essential. Next comes overview of law. Law, you need to have a complete overview. And I'll tell you a small instance. somebody gave me guidance some 54 years back, for which I am ever grateful. Says, beta, go to the library, don't read any book. Go to the library and you don't read any book, what do? No, you just walk on the shelves, look at all the titles of the spine, and when your neck gets tired, turn the other way and keep walking. You will, by the titles on the spine of the books in the library stacked, you will have a fair idea of what is law. That is essential. We have 6,000 central acts, we have so many state acts, rules, nobody can remember all this. Of course, that time there was no internet to search today, said alright, oh, come down. But that basic grounding, that picture, the human mind has to be faster than the Google. Then only you are a good lawyer. You have made your days in the law school. Don't rely. First, look at your own mind. That happens. Then, learning to learn law. Learning to learn law is more important, as I said earlier, because then you can learn tomorrow. As a lawyer or as a judge, you will need to have hundreds of various fields, economics, medicine, commerce, name it, engineering, agriculture. But if you have just the basics and you know how to pick up from the basics and go up, that is your learning. Then comes a small pie, knowledge of law. Or some knowledge you need. That is not the only thing. Today, this pie, knowledge of law, is considered the only and the end. My dear young friends, I would call you, don't treat this as the only and the only object. Then is principles of evidence and fact analysis. One of the most important subjects which I find is not given due attention in almost any university I have toured over the last 12 years. Fundamentals of fact analysis. This is essential. Then, what is reasoning and argumentation? Many times, I asked, when you are students, I asked at a higher level, what is reasoning, what is argumentation? The answer is, I will not repeat those answers, but the answers are absolutely no answers. Reasoning, argumentation, I will tell you in one sentence because I have to cut it short today. To be able to convey the facts in such a simple, succinct manner that the listener A can understand the facts and the reasoning why the result you intend as a consequence of those facts appeals to his sense of justice. Accurate picture plus reasoning. That is what matters as your argumentative skills. Not shouting more than the other lawyer would. That is not. And we often see that in court happening. Now, you have some more pages with you. Kindly turn to page 1. Item 3. Item 3 is logic. Somehow or the other, logic is so important, and yet it is neither taught nor learned. I don't know for whom it is left as teaching and learning. Some of the successful lawyers, they learned it experientially, not formally. But during the course of my research, I found a Maharashtra government's class 11 textbook on logic. And I must compliment those who compiled it. Simple, understandable. And although it is a class 11 book, I would appeal to you, it's available on the internet. In any case, I have made a PDF file. I've sent it to the university here, who will mail it to you. Please treat it, and let me tell you, you are law students here. If you are lawyers of 5 years, 7, 10 years standing, I will still make the same appeal. If you are judicial officers, I would make the same appeal. But up to a level, beyond that, it's not proper for me to speak. But that book, please keep it by your side, print out. It's 102 pages, and you will come in handy. Next, first principles thinking. Today, if you hit the Google, first principles thinking is only Elon Musk. That name appears. But there is much more to it. In fact, our Vedas have unfortunately not been credited with what is written there on first principles thinking. People talk about Aristotle. But this is where I have tried to give you a visual graphic of how alternative approaches are taken. So when a legal problem comes to you, you have to think on first principles. Don't go by what is there. Then only you get the better out of it. Next is theory of probability. Would anybody define the theory of probability? Most essential for a law student. But again, with due respect, not readily taught everywhere. But you have to say, or I request just to ensure that it is taught. All right. All of you are fond of cricket? You watch on the TV? When the coin flips, what is the probability it will be head or tail? 50-50. Right? What is the probability that when I drive back from here to my house in New Delhi, it will be raining today? It's August. 50? No. Huh? Weather report is different. What is the probability as you see the sky? Come along with that. Get it down. If you look out of the window, what is the probability? No. That means you need to learn probability. It's about 2 to 3%. And what is the probability it will snow tonight? 0. Correct. So between a range of 0 and actually in percentile you can put it 100, which is convenient. But as a mathematics or statistics, it is 1. Kindly come to page 2. This probability theory has to be learned and sink in as part of your reflex action thinking. That is essential. Kindly have that. So for anything, what is the probability he might have committed a murder? 1 in a? Follow? All right. What is the population of India? What is the number of murders we have a year? Divide. So that is the probability. And what is the probability that he jumped the traffic light? But everything you have in your mind to assign probability. You have developed your ability, yes, this is probability. Then you come, now this is again the legal method I was discussing with just now. Fact, law and application of law to facts. That is by this picture, first is fact, then what is the law? Then what is the application of law to facts? Like you match your password to your computer. That is whether those facts are established on a case do the match with the principle, with the generalized fact which are contained in a statute. Then come to page 3. Facts are 3 types. Material fact, evidentiary facts and sub-evidentiary facts. And I have defined them here. What is what materiality depends on, what is evidentiary. Then come to page 4. Facts are always chronological. So when you identify a fact, first thing is material, second is evidentiary. The next step is whether it is prior in point of time or subsequent. A prior will throw light on the next step, and the subsequent will throw light on the prior step. That is that image. Then, para 14 is the image of a railway track between Delhi to Jhansi or to Kanpur or to Kota. Where does it go? Where is the railway switch? As we say in Hindi, catchy hai rail ki catchy, either line phat gayi. Now the two switches here are at Mathura and Agra. Any of you from Mathura or Agra? Good. So you know the train comes from Delhi, it goes straight to Agra or it goes on the Bharatpur line? Yes. Right? So that is the switch at Mathura. That way, in all legal work that will come to you, the facts come. Whether they are going one direction or other. Where the direction changes place or the switch takes place is what you have to self-train yourself to identify. Next is law. In India, 99% law is statute law, unlike other countries where it is common law. Common law is case law. There is no statute. The principle of law you have to cull out of the cases. Here, we talk of case law all the time. But if I pick up 1,000 case laws, or let me take the notional 100, 98 of them will be only interpretational or applicational. They will not be case law in the sense, case law given in the absence of any underlying statute. So that distinction is first. Then another thing which I will say, and I'll also appeal to everyone present here, including your Director General, that reading a statute is most important. Learn how to read a statute. And I have given the details, para 20 onwards, how you break it into elements, how you read it, and of course, it's too much, maybe too much for you to remember, that's why copies are here. What is the emphasis of and, or, with, if? This, if this, then this. That is the syllogistic structure of a typical statute or a principle of law. But learn to read it in that form. Two examples from the IPC I have given here for ready reference, and one from the CPC. And finally, when you have done this exercise, you have a flow chart on how to read, select, and apply law to the facts. So these, my dear young friends, are the skills you need to develop today, ingrain themselves as part of your reflex thinking, and then hopefully one day we'll see you all as successful lawyers or respected judges. So with that, I'll say thank you to the organizers for inviting me. Thank you for listening to me. But the volume of the applause today is not what I want. How you feel yourself when you leave this institution and what you make of it, that is the real applause, and I'll get it in my own way. Thank you. Namaskar.
Thank you so much, sir. We also have our Director General, Delhi Metropolitan Education, Honorable Mr. Justice Bhavar Singh, sir. His Lordship graced the office of the Registrar General, Supreme Court of India, and also he is a former judge of Allahabad High Court. We now request him to please felicitate Dr. Arun Mohan, sir, Senior Advocate, Supreme Court of India. Please be seated, everyone. The results are yet to be declared. So I would now like to call Honorable Mr. Justice Bhavar Singh sir for his blessings.
This is Dr. Swami, Dr. Rashmina Pal, Dean, faculty members and dear participants. I must express my regret for the delay. Sometimes things are beyond control. And I remember many incidents, not incidents, but instances of my own court when the two side lawyers used to come to argue a case. And we would ask, how much time, Mr. So-and-so, you will take? Someone will say, 7 days, sir. Someone, and I remember there was a case of mutiny in, not mutiny, revolt in PSC of UP. Hundreds and thousands of PSC Jawans went on the rooftop of their barracks and started firing. It was a revolt within the government. Such PSC Jawans were convicted of various offences. When the appeal came to my court and I asked the lawyers how much time they will take, then they conveyed a very deterring time. One said that he will take 3 months, the other said he will take 6 months. And believe me that I heard that appeal for 6 months, but I couldn't deliver the judgment. Because I was shifted to another bench, and I still feel that it was a colossal waste of my time and also the lawyer's time. But this I have given in the context of that sometimes you have no control upon the happenings which are taking place in your court. So, and I know that now you will be in a hurry to leave this, and of course after hearing the result, you will be no more to hear me on the topic realizing your potential as a law student. So I persuaded Mr. Harun Mohan. He wanted to speak for 1 hour. So it had a deterrent effect upon me when we were getting delayed. Then I requested him, can you cut short it? So then he with great difficulty agreed to deliver in half an hour or so. So then he turned pages and pages. So, but he is a learned man. He has prepared a very good speech. We have retained it to be published in our newsletter being published by DME every quarter. So friends, you are all full of potentials, and a few things I must mention. That when you are in some criticism, or say you are facing some kind of disappointment during your profession, then maintain your dignity. It is the first potential of a lawyer. Maintain dignity. Why? Because the crisis will continue unless it is resolved. The disappointment must not must not last long, because everything in this world is perishable. And so is the problems, the crises, the disappointments. They will also wither away with the passage of time. Friends, moving faster, I would also enlighten you with a very important potential that a lawyer should always be above all the vices, and if at all potentiality is to be retained or imbibed, then all vices must be shed. You must have an office culture, working culture, no alcohol, and you know, when you are appearing before the courts, the judge may watch you or not, but the senior attorneys, senior lawyers, they always watch your potentiality, your interests, and they will at times encounter you with some or the other problems. While appearing on the other side, they may dominate the scene, but you need to observe patience at such moments. And then treat every person. It is a great potential of every lawyer. Treat every person you encounter with respect and politeness. I am fond of reading anecdotes and conveying them to others. I will refer to one anecdote on the potential, or say the potentiality of showing respect and a politeness. It is said that humble is a great virtue. There was a coolie at a railway station. I am talking of pre-independent era. He was directed to receive a British woman who was sick and required a wheelchair. The coolie, who was full of etiquettes and well manners, he arranged for a wheelchair and received at the railway platform the British lady whom he had come to receive. While making her seated on the chair, he said, "Ma'am, your hat is extremely glamorous." She was in pain of her ailment, and she said that your appreciation of my hat will not reduce my pain. "Ma'am, that is true." Coolie said, "Ma'am, that is true. But I'll pray God in the evening that you get well soon. And I'm sure you will certainly." The lady, by this second appreciation of her problem, then adverted to what he said, his politeness, the respect he had extended. Though he was a coolie, it was his profession to receive the passengers on payment, and he would have not bothered by receiving from the railway compartment, leaving to the taxi stand. Would have been enough for him, but no. He indeed prayed God that this lady, who was crying in pain, must get well soon. And it was a wonder that she recovered. She came in search of that coolie, and when he was he could have been traced. Then she expressed her gratitude towards that colleague. And gratitude itself is a potential of one's own, a lawyer in particular. Justice V.R. Krishna Iyer has referred to one very interesting story in his autobiography. When I think many of you must be knowing that Justice V.R. Krishna Iyer was a very famous judge, neither born before nor is likely to be born in future. It was said of him. He was a very erudite judge. When people wanted to read his judgments are still on record. If you want to read those judgments, must keep a dictionary by your side. He was such a wonderful judge. Before becoming a judge of Kerala High Court, he was in the profession. And since he had a communism leaning, he pro bono contested cases on behalf of the laborers and agriculturists. And he fought the first election of Kerala Legislative Assembly. And since he was a reformist kind of social activist, then the chief minister, who was from Communist Party, appointed him as a law minister. As a law minister, he visited jail once where a prisoner made a complaint against the jail authorities that they were not permitting him to go to Akashvani and deliver his performance there. He used to deliver lectures. He was a teacher. And that was the main source of income to him. And because of this restraint which has been operating against him, his family is starving. His children had been withdrawn from the school because his wife was not in a position to pay the fees of the children. So, sir, be kind enough to permit me to go to Akashvani. After hearing this touching story, Justice V.R. Krishna Iyer, who was already a socialist and reformist, he allowed the prisoner to go to Akashvani with a condition that the earnings from the lectures he would deliver on the Akashvani would straight away go to his wife. And this way, the family of this prisoner was saved from being starved. Friends, thereafter Justice Krishna Iyer went back to his legal practice and then became a judge of the Kerala High Court, then Supreme Court. And when he was 98 years of age, he had written his memoirs. In those memoirs he had written that when he was 99, he wrote this, that I am approaching to be 100. And he recollected that prisoner's story, that once after being released from jail, that prisoner along with his wife came to express his gratitude to Justice V.R. Krishna Iyer, who was the minister then at that point of time. And while leaving, Justice V.R. Krishna Iyer entertained the couple with a cup of tea. When the couple was leaving, they showered him with blessings that he must be a centurion. And he touchingly says, Krishna Iyer says, that maybe perhaps he in fact expressed gratitude towards the couple that they blessed him to be a centurion. And it is how he had expressed his feelings of politeness, gratitude towards that prisoner. So, not only a lawyer, but everyone should be in a position to express his gratitude. And John F. Kennedy said that having a feeling of gratitude but not expressing it is like a book having been written but not published. So, expressing a gratitude towards your client, towards your seniors, is a must. That must be your potential. Friends, there are many such potential aspects of a lawyer's life. I hope many of you will learn when you are appearing before the court. It is good that with the success of a lawyer in legal profession, the potentiality goes on increasing. Friends, today it was indeed a good event of client counseling. I along with the morning guest of honor, attended a few counseling sessions. I found the counseling lawyers in a very good position, advising in a correct manner to their clients. I wish that all of you have become the masters of counseling and reach zenith of your career. Thank you very much. God bless you.
It's always good to be taking part in different competitions at different colleges, and especially in DME, I really got an exposure from bar and bench both. It was an honor to hear Justice and also the chief guest, A.K. Singhal, and I'm really hopeful that this experience will be enlightening for me, and I will always treasure this experience of client counseling in my future endeavors. Thank you.
The experience of the client counseling organized by DME College was very good. I must say the quality of questions judges ask you post the consultation really make you think as to how you should deal with the problem, and they are very practical questions, and these are very rare to witness. Also, the competition was very neatly organized.
I'm Nikhil Jain. I was a judge in the client counseling competition held at Delhi Metropolitan Education Institute. I really liked the arrangements that they made and the special interest the faculty members took, and how the clients, the students of this college were told to perform in front of us. The format of the competition was quite interesting, and I believe that it helped students, the participants, gain a lot of insight into the actual functionings of litigation. I wish the college, the participants, the students and the faculty conveners the very best for all their endeavors.
Hi, my name is Abhinav Tyagi. I'm a practicing advocate. On the onset, I would like to thank the institute for calling me and letting me judge this competition. The competition was quite unique in itself, and there certainly was some learning experience. And I would like the institute to call me again. Thank you.
Hi, I'm Nishtha Kaura, and I am an alumni of DME. And it's a privilege to judge a second client counseling competition in DME. The fun fact is the first client counseling happened when I was a student and participated here. And the second client counseling is the one where I'm judging the competition. So it's obviously one of the enriching experiences.